Serious. Solicitors and lawyers. What's the worst case of, you should have mentioned this sooner, you've experienced? Story 1. The client comes to me with his new wife complaining that he's been sued by his ex-wife for failing to pay a $5,000 judgment to the ex as part of the divorce decree. The judge orders us to mediation, and during mediation, the ex-wife won't budge that she wants the full $5,000. The client claims he doesn't have the ability to pay it. The new wife, in an effort to get her loving husband free from the clutches of his evil ex, offers to give up her large diamond wedding ring to the evil ex. Ex can keep it, sell it, whatever, but the client had previously told their new wife it was worth more than $5,000, so it should be enough. Ex-wife agrees to accept the new wife's ring, subject to an appraisal. Maybe you can see where this is going. Get a call 2 weeks later from the opposing counsel. The deal is off. Why? I ask. Turns out the ring was a CZ, worth about $95. When the client met with me and I showed him the appraisal, he said, "Yeah, I knew that was going to happen." I stared at him slack-jawed and said, "You knew?" "Oh yeah, but what was I supposed to do? Tell my wife I got her a fake ring?" "How about telling her, 'No, my love, I gave you that ring and it is a symbol of my love for you and that horrible witch will get it over my body. I'll find another way to pay her,'" I said. He looked at me and said, "Yeah, that would probably have worked." Story 2. A person involved in a motorcycle accident who sustained legitimate but not serious injuries. CCTV showed the incident and they were very much not at fault. They decided this was their big payday, claimed they could barely walk, had PTSD, serious back trouble, and would never work again, the whole 9 yards. They neglected to tell their lawyer they had been 1. Working a manual labor job, 2. Riding motorcycles again, and 3. Doing a bungee jump. All of which we caught on video that they documented via social media. They did not get the multi-million-pound settlement payment they expected and were pursued against fraud. It was a fun phone call after we sent the tape full of evidence. Story 3. Doing a complicated environmental permit case for a client. The permit was granted at the city level, but the neighbors, who were not too thrilled about a business the size of our clients being next door with loud trucks moving around all day, appealed it. They have a ton of remarks, but we can deflect most of the legal ones. The only issues that really remain are that the plans are a tad bit vague and the noise issues, for which a study was ordered but not yet completed, to give a 100% guarantee there would not be sound regulation issues. To clear up the last questions, the state body did a planned on-site visit to get clarification on the few things that were not clear on the plans and the things that were filed. My firm was not notified of this visit, and as such, we were not present during this visit. Client handled it himself with his architect. They called us the next day to inform us of the following. During the visit, state body personnel had noticed that the sewage and plumbing system didn't really appear the way it was always drawn and shown, and also granted as part of the initial permit. So they asked the client to clarify where their dirty water went. Client and / architect supposedly responded with, "Oh, that just gets collected and drained down to the little stream at the back of the lot." The client wanted to know if that was bad. Spoiler alert, yes it was. There is no fixing it either. This was a company with potential environmental issues due to fluid leakage from machines and the car parks. So they had a ton of rules to follow on how to deal with your dirty and used water, separators, containment, early collection, and so on. They'd drawn most of these in their plans and were assumed to have all of this installed and working for the 20-something years that they had already been running their business on that site. According to their past permits, they needed to have those things. Announcing in the middle of an appeal procedure, so no big changes can be made to the contents of your permit request, that instead of a finely tuned sewage and waste management infrastructure that the government believes you have, you just have one big pipe chucking your water in a small stream at the back of your lot is bad. We had to explain to the client that, no, we can't fix this, and yes, you should have told us about this from the start. Is there anything else you might have not mentioned that you need to tell us about now? Story 4. Special education case. Mother and school are fighting about services. We got new assessments that backed up the mother's claims. The local school didn't have the right services, so we arranged a transfer to a larger school not too far away. Good public transit route and some extracurricular kid was excited about. She goes to enroll him in school and says they have a problem with paperwork. Thinking the transfer info just didn't get there yet, I take a copy and head down there. No, they won't enroll him because 1, not his legal name, 2, she's not his legal mom. Turns out she was the best friend of a mother who was pregnant and about to be incarcerated for drug trafficking. Friend says, "Can you take my baby while I'm in jail? I'll get him as soon as I'm out." She and her husband say, "Sure." They sign a piece of notebook paper. 12 years later, you have to think, how do they manage to navigate school and medical stuff for 12 years with no legal custody paperwork? They'd just been using an assumed last name of the pseudo-adoptive couple, and like me, no one had asked. It was only that the school had moved on to an online system that checked social security numbers against other databases that it was caught. Anyway, bio mom and dad were still alive and still in a lot of trouble. They consented to the couple that raised him adopting. The kid missed a week of school while I convinced them that he fit under a homeless youth school stability statute. Story 5. I filed a bankruptcy for a person. A few weeks later, they indicated that a creditor continued to contact them and had taken money out of their bank account, which is obviously a big no-no for people in bankruptcy. It was Monday. I knew that if I wanted to file for sanctions, I had to file the motion by Friday, so I wasn't going to jump right into it. It's best practice to try to get a creditor to correct their behavior first. I called the original payday loan store. I called the national branch. They took messages daily. Nobody was contacting me back. I asked for supervisors. Nobody was willing to talk about the situation, and I became increasingly frustrated. I'm not a yeller and I'm not particularly forceful, but even as I was reaching my limit, I called my client daily to explain that it made no sense that they were being evasive, but I was working as hard as I could. On Friday, I talked to some lower-level grunt and explained that I needed a call back in an hour from a person who can clarify the situation or the sanctions motion is being filed. I read off my time spent on the case, which would translate into thousands of dollars in sanctions if we were successful. I finally got a manager. He, very politely, tells me that the client took out the loan after the bankruptcy was filed. I remember deflating like a pop balloon. My client had taken out a relatively big payday loan a week after the bankruptcy. They confessed that they knew it wasn't included in the bankruptcy but thought the lender would go away if an attorney got involved. That's probably mild compared to the things that I see in bankruptcy, but most I probably shouldn't disclose. One of the major tenets of bankruptcy is that a debtor has to make a full and honest disclosure of their income, expenses, assets, and debts, so naturally, there are tons of reported cases of people hiding things to try to get out of their debts without surrendering assets. Story 6. Had a client charged with being a convicted felon in possession of a handgun. She had been in a car that had gotten into a on the interstate, in the middle of the night, in a rural area at least. She was a passenger and her car pulled into the state trooper post in the county I practiced in. Her car was shot to crap, so it was obvious something happened, but there was a gun in the car. She had a 30-year-old felony theft conviction, so she was charged. She had some crazy story about what happened, but it was obvious that it was a drug deal gone wrong. However, that didn't matter for her charge, really. The discovery was really light. The driver of her car wasn't a convicted felon, and it didn't appear the state police had investigated the fact that there was another car obviously at my client, even though the genesis of the was just up the road in that same post's jurisdiction. Short of it was, she had some legitimate defenses. I had met with her multiple times, discussed her case in depth, and was preparing for trial. About 2 weeks after the trial and passing, she mentioned that a state trooper had interviewed her at the state police post, which was annoying because at this point the case was 7 or 8 months old. So I looked through the discovery again and didn't see anything but filed a motion asking for any recordings of interviews. Sure enough, the prosecutor was sitting on it, which is shady as hell, unethical, and common practice for that prosecutor's office. I get the interview and all of 4 minutes in, she tells a cop not only did she know the gun was in the car, but that she had been the one That pretty much every defense I had. We had a come to Jesus talk the next day and she took her offer, which was the minimum of 5 years to serve. Story 7. How about a tiny twist with some lawyer-on-lawyer shenanigans? So another lawyer filed a document with a pretty big mistake on it. Basically, they confused two very similar motions and mixed them up. This mistake made it useless. No evidence, MSJ with traditional MSJ relief requested if anyone cares. So I go out of my way to be a nice lawyer and let them know they made a mistake. They told me, in nice lawyer talk, to go out. I go out of my way again to say, in nice lawyer talk, that if this stupid crap motion goes to a hearing, I will be quite cross and will frickin' ask for attorney's fees. In lawyer culture, this is considered a dick move. Fast forward to the hearing, after the insurance attorney finishes their impersonation of a competent attorney, I explained the basic defect to the judge. I also explained that I told the opposing counsel the following: what's wrong, how to fix it, and that I will be asking for fees. Then I asked for fees. After that, a few things happened quickly. So judge asked the Walnut if my explanation was accurate. Walnut says no. I reach into my briefcase and grab an email from me to Walnut. Walnut immediately objects in a pretrial hearing, like a frickin' walnut. Judge ignores Walnut and reads the email. Judge rules against Walnut and awards fee. Walnut says, I should have mentioned the email sooner. Story 8. I was on the other side, but I saw the other lawyer seem to have one of these moments. So the plaintiff sued, saying the insurance company had improperly denied her claim for homeowners insurance after her claim for property damage had been denied. I don't know what she told her lawyer, but as the examination under oath, like a deposition, proceeded and I laid out more of the details, I think the other lawyer understood. So basically, if a pipe bursts in your house and causes water damage, that's probably going to be covered. There's generally an exclusion that says you don't get coverage if the pipe bursts because you didn't take reasonable care to keep it from freezing. This person left her upper Midwest home at the end of the summer and didn't come back until March. Didn't winterize the house, didn't shut off the water, didn't make sure the heat was on except for a tiny heater on the second floor, and didn't even have anyone checking on the house. Well, pipes froze and burst all over the house. The water utility calls her and says, "There's a lot of water going through your meter, you might have a leak." She calls someone to go check on the house, but they can't get in because the frickin' door is frozen shut. Screw it, they abandoned further efforts to check on the house. The water utility sent someone out and they figured out that many hundreds of thousands of gallons had gone through the meter and they cut the water off at the main line. She doesn't come back until spring. Over time, there was freezing and thawing, then it warmed up, the place molded through and through. Everything in the house was completely screwed. If I had to guess, she left out a lot of those details when she described the case to her lawyer. Story 9. Working on a file for a non-EU company participating in a public tender within the EU. To summarize in a nutshell, when a government agency needs to build something like a building or a bridge, they have to organize what is called a tender procedure to weed out the charlatans and fraudsters and to enter into a contract with the most advantageous tenderer. Such a procedure is organized according to strict rules, and a lot of things are public to ensure equal opportunities for every company and to prevent bribery, collusion, fraud, etc. Serious stuff. One of the conditions to be eligible for such a tender is that your company and its directors have not been found guilty of certain crimes, for example, breaking labor laws, money laundering, corruption, as you are assumed to be untrustworthy. If you had such an issue in the past, you can fess up and try to argue this risk has been eliminated thanks to a quote-unquote self-cleaning procedure, getting rid of the bad apples in your company basically. Our client assured us that they never had any such issues and were never convicted, yada yada yada. Just one of the many steps in a procurement procedure. Years later, when the construction was well underway, it turned out they lied and the directors in their home country had been found guilty of bribery of government officials. Well, the contracting authority got rightfully spooked and argued our client willfully lied when tendering for the contract. The consequence is that you were never eligible in the first place and retroactively the tender should be annulled to restart the procedure. When asking our client what happened and why they didn't tell us so we could have tried to argue the self-cleaning exemption, they said that they didn't think it seemed relevant. It was widely known in newspapers in the language of their home country, so they assumed they didn't have to tell the authorities, and besides, many CEOs in their home country get convicted of bribery and pardoned when the opposition party gets re-elected, so what's the big deal? Literal millions of dollars and several years of thousands of people's energy down the drain, because they lied on a form. Story 10. This one is the opposite of the rest as it went in my client's favor, but I will share it because it is somewhat of a funny, happy story. I represent individuals who are applying for or have professional licenses. For example, nurses, doctors, real estate agents, roofers, etc. So one time I was retained by a guy who was applying for a nursing license to begin his second career as a nurse. The only problem is that this guy was previously charged with murder, not manslaughter, legit first-degree murder. He pled down to a lesser offense, but I know that the nursing board is not going to be thrilled with the idea of giving an accused murderer who was convicted of wrongdoing in connection with the murder a nursing license. I talk with the client about the circumstances of the murder, hoping to get some explanation that we can use to mitigate his role or put it in context. After all, he wasn't convicted of murder. But the client's explanation isn't very helpful and in fact makes it worse because, in addition to someone being killed, it was the result of a drug deal gone bad. In these types of situations, the only strategy is to take the position that your client is a changed man who made some mistakes in the past but has turned his life around. Given the well-known issues with race, class, policing, the criminal justice system, and so on, this strategy, if true, usually works, since everyone should be given a second chance, and denying a license to someone who is truly trying to be a better person often reinforces the cycle. So the day before the hearing, we prepare for hours, discussing how we are going to frame our case this way. On the morning of the hearing, the client was running late, so I had a little bit of time to kill before he arrived. On a whim, I decided to do a little research to see if there has ever been a similar case to this one. While precedent normally plays a big role in legal proceedings, these licensure cases are very fact intensive and discretionary, so the precedent is almost meaningless and not worth looking into. As luck would have it, my research leads me to an appellate decision featuring the co-defendants in my client's criminal case. In the appellate decision, the court spends a lot of time discussing the facts adduced at the criminal trial. My client pled out, so he was not one of the co-defendants during the trial. Each of the 4 co-defendants has a totally different version of what went down during this drug deal gone bad. None of the defendants can agree on what their roles were, who pulled a gun first, who had a gun, who shot first, who shot who, etc. However, there are 2, and only 2 things all of these 4 co-defendants can agree on. First, my client, who was a large, physically imposing guy, was asked to join the drug deal as the muscle, but was not really told that it was a drug deal, that guns would be involved, or that there was a possibility that it could go bad. In essence, he was told that this was a routine thing and all he needed to do was stand there and look imposing so that nobody would try anything stupid. Of course, my client could probably figure out what was going on, but these facts significantly diminished his role in everything. Second, and more importantly, all 4 co-defendants agree that as soon as someone, they couldn't agree on who, pulled a gun, my client, who was hired to be the muscle, immediately turned and ran away. In other words, as soon as there was a sign of trouble, my client absolutely noped his way out of that situation and ran like a scared rabbit. When my client arrived, I asked him why he didn't tell me these facts since they are precisely the type of mitigating factors I was looking to uncover before. As it turns out, he was so embarrassed by the whole situation that he didn't want to tell me that part. This newly obtained information significantly helped his case and he ultimately was given his license. And before anyone comments on how bad it is that someone like this got a professional license, I will note that by all accounts, he really is a great nurse and truly did turn his life around. His story shows precisely why people should be given a second chance at life, especially when, due to socio-economic factors, they were never really given a first chance. Story 11. I worked in family law for a bit, now I'm in private investigation. One case we got when I was a law clerk for a family law attorney was a guy who was a stay-at-home dad to 6 kids while his wife busted her butt. They lived essentially on a farm. The oldest kid was around 13 and wanted to show cows. The youngest was around 2 years old. The point is, these people are stupidly wholesome. Except dad comes to us for representation, out of nowhere. He wants a divorce, and so far, representing himself, it's gone completely sideways. His wife kicked him out of the house after claiming she would call the police and claim he was abusing her, so he left the house immediately and now lives in a small apartment. The guardian, ad litem, is skeptical that he can provide enough space in the apartment for 6 kids and had given his wife primary custody while he, quote, gets his life together. Additionally, he hasn't worked for 13 years because he was the SAHD, so getting a job is difficult for him. However, he comes out saying that mom recently left the kids at a public town event all by themselves, including the 2-year-old, for a full day. Essentially, she dropped them off, went to work, and then only picked them up after she had finished her shift, gotten dinner, and relaxed a bit. The kids were completely unsupervised. Dad is furious, says anything could have happened, and wants custody removed from her completely. We go to a hearing and meet in the judge's chambers beforehand. What comes out is not what our client has been telling us. Apparently, his quote-unquote sudden desire for a divorce was not so sudden. While his wife was clocking in serious overtime, he started an online relationship with another stay-at-home parent, a mom, who also had a large number of children. He decided he wanted to leave his wife for this other, still married woman. He also failed to mention to us that the reason his wife threatened to call the police was that she discovered evidence of his cheating everywhere and lost it. She did try to tell the police that he had a gun, but she didn't say he was abusing her. Finally, mom might have left the kids at the event all day, but dad knew about it and didn't do anything. He thought it could help his case if he didn't intervene. Opposing counsel showed us the text messages between mom and dad, with dad telling her on the day of the event, "I can't believe you've left them there. This is going to look so bad for you." Dad, by the way, was still unemployed. He could have picked them up, but he didn't. He was with his lover and her kids that day. We also had messages between mom and dad where dad was attempting to emotionally manipulate mom into giving him more money. He even claimed to have pictures of their children's diaries cataloging the abuse she'd put them through, i.e. eating vegetables, doing their homework, that he was going to use against her unless she paid him X dollars amount. His financial issues were actually because he kept spending half of the joint account money on his lover and her kids rather than his own, including trips, clothes, nice dinners, etc. He demanded spousal support, which technically he could get, but we had to tell him that if he married his girlfriend before the spousal support time was up, he would lose spousal support. He ended up crying about it, how it's all unfair. Yeah, buddy, so we were talking into the bonfire of your crap in front of a judge, but there we were. My position ended, it was just for the winter before his case finished, but from what I heard from the attorney I worked for, things did not get better. Story 12. Here's another. I wasn't actually an attorney yet. I was clerking for a firm and helping other attorneys on cases. We had a personal injury case for a car accident. Guy got rear-ended by a very wealthy doctor. He was never going to be able to work again in his mid-30s. Life was completely ruined because she was staring at her phone while merging onto a highway going 15 miles per hour over the speed limit. The case was set up for trial, and that's an automatic red flag as 99% of them settle. No one wants to risk the trial. Couldn't figure out why. We thought we would get him around $2.2 million. The other side was offering $700K. So I'm going through the massive file trying to figure out what they have that we don't know about. Looking at his medical, I saw he tested positive for meth a few months after the accident. I was part of the jury selection that morning, and we had 2 people with doctorates, several with masters and professional licenses, most college educated. Really not good for a guy who didn't make it through high school and was a laborer who decided to sit at home and smoke meth after his accident. Ended up settling right before the trial was supposed to start. We got a little more out of them, but far below what we expected. The guy was adamant about not settling, but we talked him into it. He would have been screwed as soon as they brought that up.